Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, you have been asked to come to court for what has been called an arraignment. What the arraignment is, just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. And the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, the felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious, it just means they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. The person is convicted of a state jail felony. Then the range of punishment is minimum 6 months to maximum 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a capital murder, then the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you earlier, your case is a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the class A misdemeanor, class B misdemeanor, and the class C misdemeanor. Class C misdemeanors are cases that start in the JP court or the city court. They come to this court when a person is found guilty in the JP court, and then they appeal their case. In essence, they ask for a new trial. They get a new trial. We call it a trial de novo. And so when the case comes here, the punishment is still the same. Now, the punishment for a class C misdemeanor is by fine only. That is, you cannot be given jail time, you only can be given a fine, and the fine cannot be above or cannot exceed $500. Now, the next highest misdemeanor is a class B misdemeanor. That was a class C, so the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. The highest misdemeanor is a class A misdemeanor. The class A misdemeanor range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. So we have unadjudicated probation and adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete that type of probation, your case will be dismissed. And you may qualify for what is called a non-disclosure. A non-disclosure means that your record will be sealed to the general public, so the general public will not have access to it, and they will not be able to find out that you were on deferred probation for the offense. Now, if the next type of probation is called adjudicated probation. So we have unadjudicated probation, and now we have adjudicated probation. With the adjudicated probation, it does result in a conviction of record. However, There is something that is called judicial clemency, where the judge can set aside the conviction. That is, if the judge sets the conviction aside, you will no longer have a conviction on your record. Now, however, if you get a subsequent conviction, that is, if you get another conviction later on, in case that you receive judicial clemency on, it can be brought back up, it can be resurrected, it can be revived, and it can be used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay, now, everyone here, well, you have an option in your case to plead either not guilty, guilty, or no contest. If you plead not guilty, you're telling the court that you did not commit the offense that you've been charged with. If you plead guilty, you're telling the court that you committed the offense that you have been charged with. Or if you plead no contest, you're telling the court that you will not be contested or you will not be fighting the charge. Okay, now everyone in here should have a clipboard. I'm getting ready to go over that information on the clipboard. Who does not have a clipboard? Here for court and do not have a clipboard. Okay, so everyone have a clipboard. Okay, so the first document on that clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. That document looks like this. Okay? Now, I will constantly refer back and forth to this document. Okay? And this document says that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first paragraph below number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date from today's date to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is a 3-page document that is also on the clipboard. That document is titled Jefferson County Affidavit of Indigence or Affidavit of Indigence. Now, this document will only be filled out for people who will be requesting a court-appointed attorney. If you will not be requesting a court-appointed attorney, you don't have to worry about signing this document. Okay? That's only for people who will be requesting a court-appointed attorney. Now, for those of you who will be requesting a court-appointed attorney, you will have to fill out the entire first page of this document. And then you go to the second page, and on the second page, at the top, it should state defendant's oath. You just fill out that portion, and basically what it's asking for is asking for the day's date and your name. And then you go down for the middle portion where it says unsworn declaration by defendant. You'll fill that portion out, and then you'll stop. Now, I'm going to give you time to fill that out. You don't have to fill it out right now, okay? Because there's some other information I need to go over with you. Now, going back to this first document that is titled Judge's Explanation of Rights to Defendants Without Attorney, the third paragraph is for individuals who will be representing themselves. Now, you have a right to represent yourself if you choose to. In essence, you can waive or you can waive your right to attorney, which means you can give up your right to an attorney. Now, if you waive or give up your right to an attorney, then that means you'll be representing yourself. And if you represent yourself, you are your own attorney. And so just like an attorney can talk to the prosecutors that are in court today, guess what? You can talk to them too. Why? Because you're your own attorney. And so this document, this paragraph states that you may not talk to the prosecutors unless you first sign a waiver of your right to be represented by an attorney. Now, the waiver of your right, now this is only for people who will be representing themselves. The waiver is titled Waiver of Rights to Defendants Without Attorney. And so it basically says that a waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You would have to read this document, sign it, and date it. And then, once you do that, you have an opportunity to talk to one of the three prosecutors that we have in court. Now, for individuals who will be waiving their right to an attorney representing themselves, this paragraph in block form states that be aware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you in your case, including the loss of significant rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens and employment, and possession of a firearm. Now, the last paragraph is for individuals who will be representing themselves. It states that you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself, and let's say you want to talk to the prosecutors because you want to see if the prosecutor might give you a fine in the case. Okay, and you talk to the prosecutor. Prosecutor says, well, no, we're going to offer probation. And you say, well, I don't want probation. Then you can say, well, judge, I changed my mind. I like to represent myself. I mean, I do not want to represent myself. I want to see if I qualify for a court appointed attorney. Or you can say, well, judge, I want to hire my own attorney. You can do that. Okay. Now, at the bottom of this document, there are 5 choices that you can make. In bold letters, it says defendant's choice. Mark these issues next to only one choice. Everybody here is going to make one choice. Okay? If you would like to hire your own attorney, sir, don't be stretching here. This is not a place to do that, okay? Okay? You need to sit up. Okay, we don't tolerate sleeping or anything of that nature. Okay? Pay attention. All right, so this first sentence is for if you would like to hire your own attorney, then you'll place your initials on the first line to the left. You sign at the bottom where it says defendant, date it, and then you'll stop. This is the only form you would have to sign. Okay? If you would like to, well, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Then you'll sign at the bottom where it says defendant. And then you'll date it today's date, July 21st, 2026. And then you'll stop. This is the only form you would have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. Okay? You'll sign where it says defendant, dated with today's date, July 21st of 2026, and then you'll fill out this form, Jefferson County Affidavit of Interest. And as I mentioned to you earlier, you fill out the entire first page, and then you go to the second page, you fill out the top portion that's titled Defendant's Oath, and then you'll fill out the middle portion that's titled Unsworn Declaration by the Defendant, and then you'll stop. Now, the next category, number 4, if you have already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. You would place your name at the bottom of this document on the line that's titled Defendant. You would date it today's date, July 21st, 2026, and then you will stop. Only form you would have to sign. Now, if you would like to waive your right to an attorney, that is, represent yourself, then you'll place your initials on the fifth line to the left at the bottom. Dated today's date, place your initials, your signature on the line that is titled Defendant. And then you would have to fill out this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And then you will stop. Anybody have any questions? Okay, Do I have any questions? We're gonna go, I need to give you some more information pertaining to the rights that you have as a defendant in a criminal case. You also have a right to have a trial by jury. That area over there, we call that the jury box. Okay, 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence that's presented by the state, the evidence that's presented by the defense. They will listen to the arguments of the state and the arguments of the defense, and then they will go back into the jury room behind that door and deliberate. And then once they finish the deliberating, they can either find you not guilty or guilty. Now, you also have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury trial. Now, if you give up your right to waive your right to have a jury trial, that simply means that you will not be having a jury trial. You still can have a trial. You will have a trial by judge. It's called a bench trial. And the reason why they call it a bench trial is because the judge sits on the bench. Okay? And so the judge will listen to evidence that's presented by the state, evidence that's presented by the defense, the arguments of the state, the arguments of the defense, and then the judge will apply the facts to the law and decide to find you either not guilty or guilty. Now, if you waive your right to have a trial period, that simply means that you enter a plea of either not guilty, either a plea of guilty or no contest. And that just simply means you want to see if you can work out a plea bargain agreement. If you are able to work out a plea bargain agreement with the state, then we call that an agreed plea bargain agreement because y'all came to an agreement. Then it goes before the judge. The judge can do one of two things. The judge can either accept or reject the plea bargain agreement. Now, if the judge rejects the plea bargain agreement that you have made with the state, guess what? You can tell the judge, well, I take my plea back. In essence, I'm not going forward on that plea. You're not filing it. And so therefore, I'm going to enter, instead of entering a plea of guilty no contest, I'm entering a plea of not guilty. You can do that. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that, you know what, I want to appeal this case because I think I've been wrongfully convicted, then the judge who followed the plea bargain agreement has to give you permission to appeal your case. If the judge gives you that permission, then your case is going to leave this court and it's going to go right upstairs to the next court. It's going to go upstairs to the County Court of Appeals. It's the 9th Court of Appeals. Okay? It's right above us. We write the little the 9th Court of Appeals, and they have 5 judges up there. And what those judges will do, they will evaluate your case, and they can do one of two things. They can grant or deny your appeal. If they grant your appeal, guess what? They can simply find you not guilty, case over. Or they can send the case back down to this court with orders to give you a whole new trial. Okay? Now, if they deny your appeal, guess what? You can appeal it to a higher court than them. You can appeal your case to the highest criminal court in the state of Texas, which is located in Austin, Texas. It is called the Texas Court of Criminal Appeals. Now, you have to file what is called a pro se petition for discretionary review. I'll explain it to you. Pro se means you represent yourself. You pro se by yourself. Okay? For yourself. And basically, what they will do, they can either grant or deny your petition. Okay? If they grant your petition, guess what? They can simply find you not guilty in case it's over. Or they can send the case back up to the 9th Court of Appeals, or they can send it back down to this court with orders. Now, if they deny your pro se petition, at that point, your conviction will stand. Okay. Now, another right that you have a right, if you don't want to have a jury trial, as I mentioned to you earlier, you can have, as I mentioned to you earlier, a bench trial. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair behind me that has the microphone in front of it. And what witnesses do, they can testify for you or against you. If you represent yourself, you can ask some questions. If you have a lawyer, your lawyer can ask some questions. We either call it direct examination or cross-examination. You also have a right against, your Fifth Amendment right against self-incrimination. What that means is a Fifth Amendment of the United States Constitution gives you a right not to say anything in case. In essence, the state, the government, the DA's office cannot force you to take the witness stand and testify against yourself. Now, I tell people this all the time, it makes sense why we should have that right. Why? Because the state of Texas, or the government, has the burden of proof. That means that they have to prove that you are guilty of this charge beyond a reasonable doubt. Guess what? You don't have to prove yourself guilty, right? So they can't call you to the witness stand, or maybe you prove yourself guilty. You don't have to do that. But so you have a Fifth Amendment right against self-incrimination. Now, the other thing is, you have a right to waive your right to call witnesses. If you do not call witnesses, that just simply means you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have a right to have what we call discovery. And what discovery is, you have a right to look at the state's file. You have a right to see your statements, witness statements, police reports, lab reports, listen to audio recordings, see video recording, documents, instruments, whatever they have, you have a right to have access to that. Now, you can waive or give up your right, which means you will not be having access to the evidence that the state will be using against you. Now, everyone in here, you have charges filed against you, you've been arrested, you've been placed in a county jail, you're out of jail on bond, you're out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay the bonds of a percentage of the bond to get out of jail. Or you're out of jail on a cash bond, which means that, you're out of jail on a PR bond or person recognizance bond, which means that you did not have to pay any money to get out of jail. I've said that to say this. Every day that you spent in jail can be used as credit toward your punishment. Now, the operative word is every day. And I'll explain it to you. Let's say last night, about 11:59, you was booked into jail. And let's say you got out at 12:01 a.m., 2 minutes later, right? You was out of jail. That's 2 days. Great. Why? Because one day was Monday and the other day was Tuesday. So you get 2 days credit, even though you was in jail 2 minutes, right? And so, every day that you spent in jail can be used as credit towards your punishment. So let's say, for example, you talk to the prosecutor, let's say you spent 5 days in jail, you talk to the prosecutor's offer you 5 days in jail. That simply means you would not have to spend any more time in jail, because the time you spent in jail will be given to you as credit for time served. So you don't have to serve any more time in jail. Now, if they are 7 days in jail and you spent 5, that means you don't have to spend 2, because you already have 5. You take 5 from 7, that leaves 2. Now, every day that you also spent in jail can be used as credit towards your fine and court costs. So every one day that you spend in jail, you're credited $100 that can be used towards your fine and court costs. So if you spend 5 days in jail, that's $500 that can be used towards your fine and court costs. So if they're offering you $500 fine and court costs, guess what? You don't have to pay anything. Why? Because the time that you spent in jail is already paid off. Therefore, it will be taxed and retired. If they offer you fine and court costs of $700 and you spent 5 days in jail, which is $500, you only have to pay $200 because we'll take 5 from the 7. Ma'am, you had your hand up?
Yes, does it have to be, okay, so if you were arrested for that one charge in a different county, you go to jail and.
You get credit for, if you're in a different county, but we can verify it, you can get credit for it. Okay. Now, the other thing is, if you cannot, like I said, if you have, let's say you had, they offered $700 fine and court costs, you spent 5 days in jail. So that means you have a $200 balance. If you can't pay it off, we put you on a payment plan. We can pay it off in small monthly installments. Now, if you cannot pay it off because you don't have the income, no problem. Because we can convert defining court calls to community service. So for every 1 hour community service that you perform at a nonprofit organization, $12.50 will be credited towards you. So for example, if you work 8 hours in one day, that's $100 that will be credited towards your final court cost. So in our scenario, you work 2 8-hour days, that's $200. And then your final court costs will be paid off. All right? Now, Jefferson County has a program for first-time offenders. So if you haven't been in trouble before, they hadn't filed any charges on you before, what will happen is a program that's called pretrial diversion. And with the pretrial diversion, they will dismiss your case if you complete it. And you can get it expunged, which means expunged from your record, which means erased, deleted, or wiped off from your record like it never happened. Okay? And in order to qualify for the program, 3 things. 1, it has to be your first time getting this 1 or more charges. All right? 2, it cannot be a foreign offense, unlawful carrying a weapon, or resisting arrest. And 3, you have to have an attorney to assist you with the application process. Okay? Those 3 things happen, you get into the program, complete the program, they dismiss the case, you can get it right off your record like it never happened. Okay. Now, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called the Veterans Court. It's for veterans only. In order to get in the program, you just have to be a veteran. And with that program, you get in the program, you complete the program, they dismiss the case, you can get that wiped off of your record. Okay? Now, this court, County Court Law number 2, has a program that is called the Community Safety Initiative. It's a program that needs to start in March of 2017. That program is designed to address the issue of what is called recidivism. Recidivism is basically where people are committing crimes over and over, one after another, they constantly get in trouble. And so, in order to address that, we have this program that is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. With that program, we have partnership with various agencies in our community. One of the agencies that we have our partnership with is Spindletop Center. Spindletop is our local mental health center in the Southeast Texas region. And Spindletop has the expertise to address mental health issues that individuals may have. They have doctors, counselors, mental health officers, and various they have different types of individuals who work within that to address mental health needs. Now, in order to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from depression or anxiety or any other host of mental illness. And they have the expertise to address your mental health needs. And basically what Spindletop will do, they will do an interview. They can do an interview either in our jury room, or they can do an interview at their facility, or they can do an interview by telephone or text, whichever is convenient for you. They will also do an assessment. And basically what the assessment is for them to determine what the mental health issue is. And then they will develop a treatment plan for either outpatient or inpatient treatment. Now, Spindletop also, yes.
That is only for after conviction, that's not.
No, it's not. It's not after conviction.
Is it prior to?
Right now. Right now. Okay. And so, they can, once they do all of those things, they also have a program, like, for example, it's not uncommon for individuals who have mental health issues to also have a drug or alcohol issue. Okay, because some people like to self-medicate. Okay, so, and so they may have what they call a co-occurring disorder or dual diagnosis. 2 things happening at the same time, drugs and alcohol and mental health. And so they have a program that is called ATAR. ATAR is a program that's called, it's an acronym that's ATAR. That stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR. It's an acronym OSAR that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery program, and what they will do a screening, which is an interview, and then they will do an assessment to determine what the person's drug or alcohol issues may be. And then they will develop a treatment plan for either outpatient or inpatient treatment. Now, if you are unemployed or if you're looking for a better job, then we have a partnership with the Golden Triangle Retirement Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It is an acronym that stands for Center, Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once individuals train in any one of those areas, they will help them to get a job in the area that they're trained in. Now, if you have not graduated from high school, or if you do not have a graduate equivalence to diploma, which is a GED, well, they have a Spinotype, as well as CICE has a GED program, which you can get your graduate equivalence to diploma. Now, all of these programs that I just mentioned to you are free, does not cost you anything but time. And I like to say in this quote, we don't just give time, we take out time. And that just simply means we do not just arrest the problem, we address the problem. And if we believe that we address the problem, we can produce productive people. And if we produce productive people will not commit crime. Why? Because they have too much to lose. So I like to say, when you come to County Court number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court, and it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, we can direct you to the people that you need to talk to so that you can get on the road to the best life. So at this time, we're going to give you time to finish filling out the paperwork. If you need help with the paperwork, just let us know. We have our court personnel, including myself, who will be happy to help you finish filling out the paperwork. Now, once the paperwork is filled out, we're gonna have you to come before the bench one at a time, and we're gonna put you into one of 3 categories. One category is you wanna hire your own attorney. And if you wanna hire your own attorney, your case will be reset today. That is, you'll be given another court date to give you time to hire your own attorney. The next category is you would like to see if you qualify for a court-appointed attorney. And if you qualify for a court-appointed attorney, you will be appointed an attorney today before you leave. Okay? And the third category is if you would like to represent yourself. If you like to represent yourself, you'll have an opportunity to talk to one of the prosecutors that are in court. And if you're able to work out an agreement, and court accepts that agreement, then that case will be taken care of today. Now, it's going to take us a little time to finish picking up the paperwork from you. And so if you need to use the restroom, there are 2 restrooms right out in the hallway. We have the men's restroom in front of County Court number 3, and the women's restroom is on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to go out in the hallways to use the restroom. When you finish using the restroom, please, come back into the courtroom. Do not leave the courthouse. You leave the courthouse, if your name is called, you're not here, then your bond is gonna be forfeited. A warrant is gonna be issued for your arrest. You will be arrested, placed in the county jail. You're gonna have to bond out, and then you're gonna get a court date, and guess what? We're gonna have to go through this here all over again. All right? And so we're gonna try to see if we can get you in and out as soon as possible. And so, on that document that is titled, Judge's Explanation of Rights to Defendants Without Attorney, there is a, line to the left, the top left-hand corner, it says State of Texas versus, on the line, please print your name. Because if your handwriting is like mine, sometimes I can't read it, okay? So just print your name so we'll know who the documents are for. So if we have any questions? Yes,
That's right. I wanna talk to the DA, but tell you want to put one?
I mean, if you talk to him, okay, that last sentence.
Yeah,
Look,
you
no,
know.
I'm gonna point it right here. This sentence says that, if you represent yourself,
Yeah,
you may change your mind at any time. So for example, let's say you represent yourself, you talk to the prosecutor, you don't like what they're offering. You can change your mind and say, well, Judge, I wanna see if I qualify for a court-appointed attorney, or if I wanna, and you can always change that.
yeah.
So-
Okay,
so-
now,
You can change it now, you can just put a line through it and put your initials on line five.
and try to change it, and talk on.
Yeah, then you're gonna have to fill out that waiver, yes.
See, qualification on an attorney, right?
Right.
You do that, get an attorney. In case you decide all today,
No, if you get an attorney,
if you get.
would you get, oh, for the appointed attorney, no, you're gonna get appointed an attorney today. And so what's gonna happen is the attorney is gonna be given a note, we're gonna send them notice by email that they were appointed to represent you. They're going to, probably get with you and set a time at their office for you to talk to them. Then they're going to talk to the district attorney, to see if they can get what is called discovery. Okay, they have access to what we call portal. They can go in there and find out what the evidence is, they're gonna talk to you, and then they're gonna talk to the DA about an offer on the case, they also talk to you about that. So that can't be, that's not gonna be done today. Yeah. Yeah, because actually, we only have one attorney in here today. Yes, ma'am.
Like, very good, ability to process paperwork. However, the issue of competency.
That's what I was going, that you can help, that's what I said earlier, if you need help.
You can help
Oh,
them
you
with,
said they, I didn't know if you meant they can help or.
no, you can help them with filling out the paperwork. And then he'll talk to his attorney, and his attorney will, whatever thing they need to file, they'll do that.
You addressed the stereotype situation related to competency with drugs, with mental health outside of drugs. Autism.
No, that's the first thing I talked about was you don't have to be insane or incompetent. You just suffer from depression, anxiety, or any other mental health issue. Okay, participate in that program.
Thank you.
Anybody else have any questions? Okay, so we're going to go into recess at this time. First of all, be mindful that we're still in court. Okay? And so since we're still in court, please conduct yourselves accordingly. Okay? Y'all here for some? Hmm?
Yeah, I was gonna-
Y'all can have a seat in here and just, y'all can sit over there and, hear about it.
Yeah, it's not your first time here, you didn't right now. All right, if you're done with your paperwork, you can bring it up to me. Please just don't hit it when you go over it before you walk away.
Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCCR 2950. Case is called the State of Texas versus Kason Morris. Mr. Morris, is that your full name?
Yes, sir.
Mr. Morris, would you please raise your right hand? Mr. Morris, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Morris, you may put your hand down. How are you doing, Mr. Morris?
Pretty good. How about you, Your Honor?
I'm doing fine. Thanks for asking. And Mr. Morris, you are represented in your case by your attorney, Attorney Jack Lawrence. And Mr. Lawrence, how are you doing?
Just fine, Your Honor.
Mr. Lawrence, do you waive a record in Mr. Morris's case?
Yes, I do, Your Honor.
And the state is represented in this case by Attorney Farrah Nixon. Ms. Nixon, how are you doing?
I'm fine, Your Honor.
That's good. I'm doing fine. Thanks for asking. Now, Mr. Morris, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Kason Morris, on or about October 22nd of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Morris, do you understand what you have been charged with?
Yes, Your Honor.
To discharge Mr. Morris, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
Are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Mr. Morris, I also have before me on my computer tablet a document that is titled Misdemeanor Pre-Admonishment. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there are a set of initials KM on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, Your Honor.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
We have the discovery certificate. I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
Now, Mr. Morris, before you signed and initialed all of the documents that I'm showing you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, Your Honor.
Is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Morris, are you a citizen of the United States?
Yes, sir.
State offer States Exhibit 1.
The state is offering State's Exhibit number 1 in this case. Mr. Lawrence, do you have any objections?
No objection, Your Honor.
No objections. State's Exhibit number 1 will be admitted. Now, Mr. Lawrence, you have advised and counseled Mr. Morris. Is there any evidence that your client is currently mentally incompetent to stand trial?
None at all, Your Honor.
Okay, Mr. Morris, you understand all of the paperwork that you signed?
Yes, Your Honor.
You have any mental issues that interferes with your ability to confer with your attorney?
No, Your Honor.
And you understand the consequences of your plea?
Yes, Your Honor.
Okay. Now, Mr. Morris, are you satisfied with the representation of your attorney?
Yes, Your Honor.
Has he provided full and competent representation on your behalf?
Yes, Your Honor.
Okay, now, Mr. Morris, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
This is terms are as follows: 6 months deferred probation, $50 fine, 24 hours community service, and evaluation by Spindletop with credit for 6 days jail.
Oh, okay. What's the court cost?
$362.
Hey, that take up, okay. 62. And Mr. Lawrence, were you appointed in this case?
Yes, I was, Your Honor.
Okay. It's 53, 62. That's 6 days credit, you said?
Yes, Your Honor.
Okay, so that's so like that. So it's just- Okay, Mr. Morris, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you will be required to pay a fine of $50 for court costs of $362. Now, the fine and court costs, which comes to a balance of $412, you have 6 days credit that will go toward that, so it'll wipe that out. Okay, so it's already, your fine and court cost is already paid for because of the 6 days that you spent in jail. All right, now you'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you're required to reimburse Jefferson County court-appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you are required to pay each month while you're on probation, is $163 a month. Are you able to pay the $163 a month?
Yes, sir.
All right. You will also be required to perform 24 hours of community service. You're required, as a condition of this probation, to have an evaluation by Spindletop. And you were required to adhere to all the other standard terms and conditions of this probation. Do you understand?
Yes, Your Honor.
Now, do you understand the state's offer?
Yes, Your
Do
Honor.
you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Morris, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Morris, If you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure where your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters.
Yes, sir.
Now, Mr. Morris, again, I'll follow the plea bargaining agreement in this case. Mr. Morris, you're going to stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go. And you have a blessed day, and they'll give you some instructions on where the probation office is. Okay, look at it.
Yes, sir.
And you have a blessed day.
You too, thank you.
Okay, and you have a blessed day as well.
Thank you, Your Honor.
Okay, you are.
And, that is a directive, for,
It's in his,
stop.
this is in his probation papers. That's a condition of his probation.
Good, thank you, Your Honor.
Okay. Okay. We have anybody, she have a paperwork?
Thank you.
Next case is, cause number 24 CCCR 1305, case is style of state of Texas versus Darius Shaw. And cause number 24 CCCR 1304. Shaw, would you please come up, stand in front of the bench? Mr. Shaw, your full name is Darius Shaw?
Yes, sir.
Mr. Shaw, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Shaw, you may put your hand down. How you doing, Mr. Shaw? I'm doing fine, thanks for asking. Mr. Shaw, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes.
Now, before you signed and initialed this document, did you read the document? Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Shaw, your case is going to be reset. You're gonna stand in front of our court coordinator. She's gonna give you reset. Once she gives you your reset, you'll be free to go and you have a blessed day.
Yes, sir. You too.
Jason West. Mr. West, how are you doing?
Good.
Oh, I'm doing fine. Mr. West, your full name is Jason Michael West? Mr. West, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. West, you may put your hand down. Mr. West, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state that you would like to hire your own attorney? Now, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. West, your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is gonna reset your case. Once she resets your case, you'll be free to go and you have a blessed day. You have to lower your voice.
Okay, y'all need to lower your voices.
And if y'all need to talk to him, y'all can either go in the jury room or out in the hall. Okay, all right, you can get your reset.
Thank you.
Jefferson County Court at Law number 2 is in session. Court is in session and calls number 26 CCCR 1184. Case is filed with State of Texas versus Charles Earl Darcy.
Yes.
Mr. Darcy, is that your full name?
Yes, sir.
Mr. Darcy, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Darcy, you may put your hand down. How are you doing, Mr. Darcy? That's good, Mr. Darcy. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Darcy, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Darcy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall
Yes, sir.
and wait for your name to be called.
Yes, sir.
You're welcome. Let's see. What are you talking about?
Yeah, I said first.
Oh, she does?
Yeah, I will make that talk to him.
Oh. We'll just bring her over tomorrow then.
So Lord say, okay, makes sense.
Okay, we'll just bring her over tomorrow. Okay, she's going to ISF.
Would volunteer to work for you.
Okay. That's Darcy. Is that Jennifer? Jennifer Sykes?
Yeah, other skill, our other one.
Ms. Sykes, your full name is Jennifer Lynn Sykes?
Correct.
Sykes, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
Ms. Sykes, you may put your hand down. How are you doing, Ms. Sykes?
Very well.
I'm doing fine, thanks for asking. Ms. Sykes, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that is titled, that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Sure.
And on page. It's out of order. And on page. Yeah, it's, I don't know, you're supposed to put your signature there. The signature doesn't look nothing like the signature on the first document. Did you show these documents? Yeah, you can correct, give her a pen. Yes, it's gonna be, Albert Price. Okay, Ms. Sykes. On this document that is titled Jefferson County Affidavit of Indigence, is this your signature on the line that's titled Defendant?
Correct.
Now, Ms. Sykes, before you signed and initialed these documents, did you read the documents?
Yes,
Did you
sir.
understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Absolutely.
Ms. Sykes, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Alpha Price. Attorney Price will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Represent the state of Texas at work.
There you go. There you go. Herbert August Smith. Mr. Smith, your full name is Herbert August Smith.
Yes, sir.
Smith, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Smith, you may put your hand down. How are you doing, Mr. Smith?
No, man.
That's good. Mr. Smith, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have oh, he didn't even sign this one.
You got it.
Okay, now, Mr. Smith, I also have another document. This document is titled Jefferson County Affidavit of Indigence, and is this your signature on page 2?
Yes.
Now, Mr. Smith, before you sign and initial these documents, did you read the documents?
Yes.
Do you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Smith, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. Here you go. Pete Garrett. Is that the gentleman that's asleep? Keith Garrett? Who's Keith Garrett?
Yeah, pay for it?
I have okay,
I am not.
I had him checked us being here. He must not be here. Nelson Garrick? That's you? Okay.
They sound timely spoken.
Okay. Mr. Garrick, your full name is Nelson L. Garrick. Garrick, could you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Garrett, you may put your hand down. Mr. Garrett, I have before me two documents. First document is Charles Rojas. First document. Okay, the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initial on the line that state you'd like to apply for court appointed attorney?
Yes, sir.
Also have another document that is titled Jefferson County Affidavit. And just on page 2, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Garrett, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
Okay. All right. Yes, on the docket that he had a felony.
Well, just meet with us, meet with us.
This is Garrett, Nelson Garrett. He's Joel Vasquez. Need some bond conditions. Bond. Okay. This is cause number 26 CCCR 1424. Case is style of state of Texas versus Isabella Leva. Okay, Ms. Leva, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Leva, you may put your hand down. How are you doing, Ms. Leva?
Good.
That's good. Ms. Leva, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. And Ms. Leva, do you recognize this document? Is this your signature on the line that's titled defendant? You have to speak up, ma'am.
Yes.
And are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigenous. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Ms. Labor, before you sign and initial these documents that I'm showing you, did you read the documents? Did you understand what you read?
Yeah.
Is everything in these documents true and correct to the best of your knowledge?
Yeah.
Ms. Labor, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Okay. Is this the last one? I thought I had some more. Let's see. Could you make a copy? Oh, need some more copies of this here. This is the last one. Also, I need some copies. That's the last one. if he violated any of these conditions, his bond can be revoked. He'll be arrested and placed in the Jefferson County jail. Okay, now he has, I think Charles Rojas is his attorney. Okay, Mr. Rojas is gonna contact you and you should contact him. Y'all should meet. And I'm sure he's gonna set up an appointment with y'all. And then Mr. Rojas is gonna advise you as to what he will do from that standpoint, from that point on.
And condition number 3 is why you asked about going back to school, because we can't do that since.
Well, I asked that, but I'll just read the conditions. It's following return of a criminal information in County Court Law number 2. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall not commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? He can't break the law. Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to tests for drugs and alcohol when directed to do so, or submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Sure.
Now, the next thing is the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, let me ask you this question. Let me see, this incident occurred on April 15th of 2026. Okay, has he been in summer school?
No, we just finished out the last semester on campus.
Okay. Are there any type of disciplinary actions that's being taken that have you been contacted?
They did a 3-day suspension, which was, I think the 15th was a Friday, and it automatically did a meeting, so that was it. Whenever they went back, they just said, again, look into this, hire an attorney, because this is crazy. So
Okay, now let me ask you this here. When is school scheduled to start?
second week of August,
Second week of August.
18th or 20th, something like that.
Okay. When is the registration? Okay, has he registered?
It's either I'm paying tuition or paying for an attorney.
Huh?
I'm paying for an attorney or I'm paying for a tuition. That was what I.
Well, this attorney is being appointed. You're not paying for this attorney.
Just found it out today, so I don't know. I probably, he wants to go back there, so more than likely gotta let him finish his school. He's autistic and he got this far. I gotta do something, so. I don't want him to, he wants to. So. No.
Well, I understand that. Who have you been communicating with it on Lamar University's campus?
It's this from the student center. I forget his name is Daryl. I believe his name is Daryl something, that guy with the card. It's the student center. It's the.
Okay.
Like when the stuff happens.
Now, what I'm gonna do, I'm gonna reset this case for a week.
Okay.
Okay. And we need to get some more information regarding him being allowed to go on campus. Because it's not uncommon for the Lamar to give what is called a trespass warning.
Okay.
Which means that if he went back on campus, if it was trespass one, then they'll be filing trespass charges against him.
So they did issue that the day that he was arrested, 3 days. So, oh, sorry, 7 days. So from Friday, and then I think we met with him that next Wednesday, he'd been back on campus. He did finish out he lived on the dorm, he did all of that last semester for April and May.
Okay, hold on a minute.
advising that all privileges on Lamar campuses have been revoked for Mr. Smith. This was on April 15th, at 5:30. If there were specific allotment for him to finish off the semester or for him to, be allowed to take exams, Judge, that's one thing, but I submit to this court that on April 15th, a trespass warning was given and his privileges on campus had been revoked.
Okay.
Do you have the paperwork showing when it was lifted?
Well, let's do this here. We'll be back in a week.
Okay.
You want them to, so,
We probably need to put this on a what?
Tuesday, or Wednesday.
I'm trying to think the date for him to come back.
She forgot one of those. Well, they'll call.
Oh, that's right. Tuesday
He'll
be
put out.
better because Spinnertop will be here.
Okay, well, I'll put them.
Right. I just, yeah, right now, you're gonna be prohibited from, based on that, you can't go back on Lamar campus because they gave him a trespass warrant. Now, whatever paperwork you have, you need to get that to your lawyer,
Okay.
and they can look into whatever he needs to look into. And then when we come back here on next Tuesday, perhaps he'll have some additional information to provide to the district attorney's office.
And that's just to make sure that that trespass has been lifted?
Well, I mean,
Or just-
he's gonna look into whatever, a lot of stuff that you've been saying,
Okay. Okay.
okay? Okay, so at this point, condition number 2, you cannot have any, drugs. He shall submit the testing for drugs and alcohol anytime as the court direct him to. And 1, if he tests positive for drugs, his bond can be revoked, or if he refuses to take a drug and alcohol test, his bond can be revoked. Now, 3, he shall not communicate either directly or indirectly with the alleged victim of the pending offense, and he shall not go near any residence, school, or other location frequented by the alleged victim. Now, obviously, we know the school is Lamar University. Now, 4 does not apply. However, 5 does apply, and it states he is prohibited from possessing a firearm or ammunition unless he is a peace officer. We know he's not that, as defined by section 1.07 of Texas Penal Code. Actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that?
Yes.
Now, this is another one is usually 7 should wear a GPS monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days after the day.
Huh?
Yeah,
Yeah, Your Honor, the state's going to submit, since the person who stands before you, who also stands accused, he's accompanied by his mother, Judge, then she should be made, she should supply her name and be made third-party custodian, since she's been speaking for him before the bench during this announcement period. If she's been made the third-party custodian and assume all responsibilities as those bond conditions, then the state will waive the requirement for electronic monitoring, Judge. She would have to assume the conditions. He spoke very little. She spoke on his behalf. She must assume that responsibility, Judge.
okay, now, 2 things. Let me do this here. So he said, all bail bonds executed based of any defendant named herein or orders subject to the additional condition. Number one, defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition?
Yes, sir.
Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test in the case of presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. I say, okay, well, go ahead and say what you're gonna say.
My, it's crazy because we go to the same church. I'm a deacon, she's an usher. We go to the same church still. We still married. And
I understand.
pastor said that he would sign an affidavit saying that I could still come to church. But I understand what you're saying, so I'm just gonna let you know the court said I can't come to church.
I'm just
reading.
I'm just reading what it says. You shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. I mean, I don't know what stage your divorce is in. I'm sure they should have some temporary orders, huh?
No,
I know. Is y'all in the process of divorce?
it was talked about, but we
So it never was filed.
no, yeah, it was filed. It was filed, but we reconciled.
So it was dismissed,
What?
the divorce.
I've been calling the district, I think it's 252 or 279 or whatever, but they hadn't said no court date. They said we're gonna have a court date.
So it's still pending. I mean, that's basically what you're saying. You saying reconcile and all this other stuff. And when you use the term reconcile, that means that, y'all divorce, y'all cancel the divorce and y'all back together. That's what reconcile means.
That's correct.
There's no divorce.
Correct.
But from what you're saying, there is a divorce because it's in the 279th District Court. You just don't have a final date.
Just, but I understand what your concern is, y'all. I do.
Oh, yeah.
This was
I mean,
Yeah.
I guess the gentleman that your wife may be dating must be a new boyfriend. But I think here it says her fiance, but the point is you cannot go in any, and the other thing is the concern is you got a picture of a residence when you was making these statements. And so obviously you was right outside the residence. Okay, so you can't go around the residence, okay?
Yeah, correct. I understand.
Okay, I don't know if you're trying to see who's over there or what, but you can't go there.
I understand.
All right, so, and so, I don't know.
That's why I'm asking to get.
Well, it kind of almost look like a little stalking. Could be going on. That's what it kind of look like.
The picture was actually sent to me and I sent it to her, which I shouldn't have did.
Well, I don't know. You don't have to give it
I
on.
understand.
I'm just saying, just based on what this
Yeah.
probable cause information is saying,
Yeah, I
okay?
understand.
So you can't, so you understand that condition. Now, condition number 3 does not apply. Condition number 4, does not apply. 3 does apply. Condition number 4 does not apply because that only applied to DWI cases. Your case is not a DWI case. Condition number 5 does apply and states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state or state agency or political subdivision. Do you understand that?
Yes, Your Honor.
And condition number 7, the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You can have a seat in that first chair on the wall, wait for your name to be called. Your attorney in this case is Attorney Langston Adams. Okay? You could have a seat in that chair and wait for your name to call. You have a blessed day. Here you go, where's the, oh, you're gonna have to make a copy of the bond condition. And do we have, I see we have something on Douglas Watley? Did I pronounce that right?
Yes, sir.
Oh, okay. You have his paperwork, the, what? Mr. Watley,
Yes, sir.
your full name is Douglas Dwayne Watley?
Yes, sir.
Mr. Watley, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
Mr. Watley, you may put your hand down. How are you doing, Mr. Watley?
I'm doing good, Judge. How are you?
I'm doing fine, thanks for asking. Now, Mr. Watley, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled?
Yes, sir.
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that's titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Is this your signature?
Yes, sir.
Mr. Wadley, I also have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Douglas Dwayne Watley, on or about February 26th of 2026, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of impersonating a security officer. Mr. Watley, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Watley, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Watley, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1.
Yes, sir.
Do you recognize this
Yes,
document?
sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked no contest. Did you place your initials in this location?
Yes, sir.
And a second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest.
Yes, sir.
Did you place your initials in this second location? On page 3 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line
Yes,
that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that
Yes,
statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Watley, before you signed and initialed all of the documents that I'm showing you, that I just
Yes, sir.
showed you,
Yes, sir.
did you read the documents?
Yes, sir.
And did you understand everything that you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Watley, are you a citizen of the United States?
Yes, sir.
State Offer States Exhibit 1.
Mr. Watley, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is the same document that you acknowledge on this tablet This is the same document that has your initials in the two locations on page 2, and it has your signature on page 3.
Yes, sir.
Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's exhibit number 1 will be admitted. Mr. Wiley, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Wiley, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That would be, we would ask that the court defer adjudication in this case for a period of 6 months and impose a fine of $500.
And he has 1 day credit?
That's correct, Your Honor.
Okay, let's see. What's the court cost?
277.
Okay, Mr. Wiley, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $500 plus court costs of $277, which comes to a total of $777. You have 1 day credit, so the 1 day credit will go toward the payment of your fine and court costs. It's $100. So instead of $777 fine and court costs, it's $677 fine and court costs. Do you understand that?
Yes, sir.
You also be required to pay a probation fee of $60 a month, reimbursement fee of $15 a month, a urinalysis fee of $15 a month, and a reimbursement is a flat fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $228 a month. Will you be able to pay the $228 a month?
As of right now, no.
Okay, we have an affidavit on him.
That's 677.
There's no community service. Right. Mr.
You guys correct, Your Honor.
Okay.
Did you keep that? Didn't you fill something out?
Yeah, I got it to you.
He did?
No, the other paper, I think you started filling the income and stuff.
No, ma'am. No, ma'am, I never did.
Somebody else told me keep theirs.
Okay.
Okay, fill this out.
This one. Zero.
Zero.
Like, BS in my work.
Oh, there it is, yeah. 108. 0.
Did you just say BS in my court? Listen, did you hear? I mean, I'm more here.
I am too. If I did,
If you don't have a patient to sit with him, you can step outside of my courtroom, sir.
Yes, ma'am.
Outside of my courtroom.
Yes, ma'am.
Can we get mine?
Okay, so this is gonna be, it's 150. 90. That's it? I mean, it's just 240 divided by 5. Okay. Is he? Still filling it out.
I can tell you he's not gonna be happy if you try and put something in community service.
Well, it's still an option.
I don't know. I could extend it if he's willing,
Yeah,
so it's less a month.
yeah, let me do this here, 240 divided by 48. Okay, now, Mr. Watley,
Yes, sir.
I have before me a document that is titled information. Yeah, this information. Well, excuse me, I have a document before me that's titled affidavit. You recognize this document?
Yes, sir.
And is everything in this document true and correct today?
Yes, sir.
Okay, now, Mr. Watley, the court is gonna find that you're indigent based on the finding with indigency. The the remaining fine of $400 plus court costs of $277, which comes to a total of $677, will be converted to 54 hours of community service. Okay? And the probation fee in this month of $60 a month will be reduced to the statutory minimum of $25 a month.
Yes, sir.
You understand that?
Yes, sir.
And the court is going to waive the reimbursement fee of $15.
Okay.
You will be required to pay your analysis fee of $15 a month. Now, your total monthly installments, that is the total amount that you will, I think this is, yeah, that you will be required to pay in this case is $48 a month.
Yes, sir.
Okay? Now, you will also be required to adhere to the other standard terms and conditions of this probation.
Yes, sir.
And do you understand the state's offer?
Yes, sir.
And do you accept the state's offer and the findings that the court have made in this
Yes.
case?
Yes, sir.
Okay? So I got it down here. I'll change.
Hours community service? I'll just have to get with my fire chief. I don't know.
Okay. And so let's see. Now, if you do, and do you accept this, right?
Yes, sir.
Now, if you successfully complete this probationary period, this case is going to be dismissed. It would not result in a conviction on record, and you may qualify for non-disclosure, whereby your record will be sealed to the general public. Do you understand that?
Yes, sir.
All right. She has to redo the paperwork. Just have a seat in that first chair and wait for your name to be called.
Yes.
Okay. Okay, who's the next gentleman? Kareem Assam Anatawi.
Yes, sir.
Mr. Anatawi, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
I'm all right, small.
You doing all right?
Yes, sir.
All right, now, Mr. Anatawi, you initially stated that you would like to waive your right to an attorney to represent yourself, is that correct?
Yeah,
And you talked to the prosecutor
right.
about your case, and then, so you have not been able to come to an agreement,
No,
that's right? So now, so you're rejecting the state's offer,
yes, sir.
okay? Now, you have three options. Well, if you still want to represent yourself, you
No.
can. If you don't, okay. Your next option is you can hire an attorney. If you can hire an attorney, your case will be reset to hire your own attorney. Or you can apply for a court-appointed attorney,
Yeah, I want court appointed attorney.
okay? Miss, I think you might have to scratch that out or something. Oh, okay, here we go.
The paperwork.
I got it. I got this here, but I just need his initials. His initials will scratch through. He marked through the initials on the court appointed attorney. You're gonna have to maybe wipe that out and
Yeah,
so it can be clear. You're gonna have to, he gonna have,
I started out with the court appointed.
yeah, okay, you're gonna have to scratch through
Straight
the,
it all out.
Mhm. And it's already. you
so
already
that'll
got
be, that'll be.
Oh, yeah, do it, yeah, I do it.
All thing he has to do is, yeah, I have his,
Wait,
Nah, that's not a lot.
wait. Not right there,
Yeah.
right here. Where you already get it marked out at. Thank you. You're good.
and a towel. Oh, he has an assault. Huh? Defendant. Kareem. Okay. Mr. Anatawi, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And is this your signature on the line as titled defendant?
Yes, sir.
Are these your
Yes,
initials on the line that state you like to apply for court appointed attorney?
yes, sir.
I also have another document that's titled Jefferson County Affidavit of Indigence. And is this your signature on the line that's titled defendant signature?
Yes, sir.
And Mr. Anatawi, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Anatawi, I read your answers. Based on your answers, you meet the eligibility requirements of the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. And you will be given information to contact him. But before we give you that information, I need to give you some bond conditions. I'm gonna have to sign it and she's gonna have to make a copy.
Okay.
Okay, July. Here you go. You make that copy. Okay.
You wanna make?
Now, Mr. Anatawi, we're gonna give you some bond conditions. And you will be given a copy of these bond conditions. Okay, Mr. Anatawi. Bill just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. You see that document? Mr. Anatawi, I'm getting ready to go over this document with you. And it states that following return of criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendants shall commit no offense against this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Mr. Anatawi, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, Mr. Anatawi, you will stand next, we'll have a seat in that chair and wait for your name to be called. Once your name is called, you go to the window, follow her directions. When you finish following her directions, you'll be free to go.
Yes, sir.
And you have a blessed day, and your attorney should be contacting you within 24 hours.
All right, thank you.
You're welcome.
Thank you.
You're welcome.
That was it.
Let's see. Bond forfeiture. What happened on Joel Vasquez had a Brandon LaFleur?
Yeah, was placed into custody
Okay,
in CDC. Oh.
okay. Okay, so he's in jail. And the time we was appointed, Tom Burbank. The other stuff was I had some essence that was, yeah, sure, yeah. Let's see. Now Keith Garrett. Keith, okay, Keith Garrett. See that you had him as being here. Okay. Keith Garrett was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Keith Garrett. We had him as being here. Keith Garrett did not answer. He has not appeared in court since the court has been in session. The time now is 12:38 p.m. on today's date. Ms. Bailiff, would you please call the name of Keith Garrett at the courthouse door?
Oh,
Is that the one that say yes?
yes,
Yeah.
that's, I think it's
He
like
had-
when
he
more
had
with the
LVD.
kid.
Oh.
The mom,
Huh?
that was the one when the mom came in.
Oh, okay. Okay, so would you
Yeah.
please call the name of Keith Garrett at the courthouse door?
Garrett. Garrett. That was fine, John.
Okay, Keith Garrett's name was just called again at the courthouse door. Keith Garrett did not answer. A reasonable time has passed to give Mr. Garrett the opportunity to appear in court. He's not appearing in court. State, do you have a motion?
Yes, Your Honor, statement is for bond forfeiture.
That motion will be granted. Keith Garrett bond will be forfeited and warrant shall be issued for his arrest in cause number 26 CCCR 1442. Next case is cause number 26 CCCR 0322. Case is styled the state of Texas versus Ronnie Jean. Ronnie Jean was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the courts called the name of Ronnie Jean at the courthouse door. Ronnie Jean did not answer. A reasonable time has passed to give Mr. Jean the opportunity to court. He has not appeared in court. The time now is 12:39 p.m. on today's date of July 21st, 2026. Ms. Bailey, could you please call the name of Ronnie Jean at the courthouse door?
Ronnie Jean, Ronnie Jean. Nurse Marjorie.
Ronnie Jean name was just called to get at the courthouse door. Ronnie Jean did not answer. A reasonable time has passed to give Mr. Jean the opportunity to appear in court. He has not appeared in court. Faith, do you have a motion?
Yes, Your Honor, state minister bond forfeiture.
That motion will be granted. Ronnie Jean's bond will be forfeited and warrant shall be issued for his arrest in cause number 26 CCCR 0322. Yeah, that's it. Okay, this will conclude the calling of the court's arraignment docket on today's date, July 21st, 2026, in County Court at Law Number 2. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you're excused.
Thank you, Your Honor.
Who? He was arrested in
Oh, that was-
CDC.
yes. Yeah.
That was the one that came in here and said